So with the power vested upon me, I hereby call its 20th General Membership Meeting to order. Our host for this evening is no less than our past Deputy District Governor, Conrado Rani Caballero. A round of applause.
Thank you, President Burns. Good evening, welcome to Club's 20th General Member. I am your host for tonight and past President Liparda. To start with our meeting, we'll have our opening prayer and national anthem, then to be followed by the four-way test and introduction of officers and members of the club. Okay, please.
Huwag kang mangamba, di ka nag-isa. Sasamahan kita saan man magpunta. Ika'y mahalaga sa aking mga mata, minamahal kita. Minamahal kita. Sa iyong pangalan, ikaw ay akin magpakailanman. Ako ang Panginoon mo at Diyos, tagapagligtas mo at tagatubos. Huwag kang mangamba, di ka nag-isa. Sasamahan kita saan man magpunta. Mahal kita, minamahal kita. Sa tubig kita'y sasagipin, sa apoy ililigtas man din. Panginoon mo at Diyos, tagapagligtas mo at tagatubos. Huwag kang mahal kita.
Mga kababayan, ang pambansang awit ng Pilipinas.
As a flag of peace unfurled, I shall serve my community, help achieve universal unity. To Rotary, I shall dedicate my all. World understanding shall be my cherished goal. With a four-way test, I'll pursue my quest, giving my little way help attain. Peace in the world, I shall not have lived in vain. Above self, lend a hand to all who need my help. I'll get my spouse to involve in Rotary, and in Rotary ways I will train my family. With a four-way test, we'll pursue our quest, living our little way. Peace in the world, we shall not have lived in Build a bridge for tomorrow's youth, strengthen nothing but the truth. Let's join our hands, there's no reason we'll divide. We shall all understand why the good Lord is our guide. With a four-way test, we'll pursue our quest, giving our little way of the day. Peace in the world, we shall not have lived in vain. Peace be achieved, we shall not have lived in vain.
four-way test of the things we think, say, or do. Is it the truth? Is it fair to all concerned? Will it build goodwill and better friendships? Will it be beneficial to all concerned? Object of Rotary is to encourage and foster the ideal of service as the basis of worthy enterprise, and in particular, to encourage and foster: first, the development of acquaintance as an opportunity for service. Second, high ethical standards in business and professions, the recognition of the worthiness of all useful occupations, and the dignifying of each Rotarian's occupation as an opportunity to serve society. Third, the application of the ideal of service in each Rotarian's personal, business, and community life. Fourth, the advancement of international understanding, goodwill, and peace through a world fellowship of business and professional persons united in the ideal of service. Presenting the Rotary Club of Cebu Fuente, Officers and Directors, Rotary Year 2021-2022. Attorney Bernardino T. Amago IV, President. Polly Jang, Vice President, President-elect. Jose Marie Ponce, Secretary, President nominee. Architect Manuel L. Torres Jr., Treasurer. Patrick L. Yared, Auditor. Emmanuel P. Tesalona, TRF Chair. Stephen Henry Uy, Club Administration Officer. Maricel Borromeo Amores, Membership Director. Jason Go Kyang Ki Ong, Community Service Director. Marina Enriquez Kaufman, Vocational Service Director. Jose Alfonso C. Abad, International Service Director. Attorney Lolita L. Lomanta, Youth Service Director. Christopher A. Ligonas, Public Image Director and CICO. Dave John B. Karamihan, Protocol Officer. Engineer Jesalito V. Baring, Sergeant at Arms. Meet our advisors. Architect Joseph Michael P. Espina, Assistant Regional Rotary Foundation Coordinator. Mary Ann Alcordo Solomon and Paulianao Zone Coordinator. Richard G. Barba, District Trainer, Rotary Year 2016-2017. Conrado M. Abarintos, Deputy District Governor for Operations, Rotary Year 2015-2017. Maria Consolacion Abad Pasion, President, Rotary Year 2013-2014. Maricel Borromeo Amores, Assistant Governor, Area 1B. Meet the distinguished men and women of the Rotary Club of Cebu Fuente with their classification. Jose Alfonso C. Abad, Non-Life Insurance. Conrado M. Abarintos, Government Customs Finance. Eman Rayan C. Abay-Abay, Customs Brokerage. Attorney Bernardino T. Amago IV, Academe Legal Services. Attorney Ernesto Miguel B. Amores, Civil Service Commission Legal. Maricel Borromeo Amores, Human Resources Consultancy. Richard G. Barba, Printing Services. Engineer Jesalito V. Baring, Environment Consultancy. Emmanuel C. Kalalang, Multi-Purpose Cooperative Management. Attorney Cedric Jose Andre G. Deperine, Corporate Law and Litigation Services. Glenn Ford A. Alendrino, E-Commerce Management. Architect Joseph Michael P. Espina, Architecture Planning. Polly Jan, Coffee Shop Management. Dave John B. Karamihan, Manpower Outsourcing Services. Marina E. Kaufman, Hotel and Restaurant Services. Christopher A. Ligunas, IT Services. Attorney Lolita L. Lomanta, Prosecution Services. Jason Gokyang Ong, Manufacturing Operations Management. Maria Consolacion A. Pasion, Games and Amusement. Jose Marie Ponce, Memorial Plan Investment Services. Geraldine B. Ramos, Forwarding Services. Maria Dolores Rimas, Resort Management. Luz Filipinas S. San Pedro, Metal Engraving. Herminia Fernandez Spaller, Construction and Industrial Supplies Trading. Dr. Alan O. Sinerpida, Plastic Surgery. Mary Ann A. Solomon, Outdoor Advertising, Signage Design and Production. Hendrik S. Sulay, Retail Management. Emmanuel P. Tesalona, Precious Metal Trading. Alfie M. Torres, BPO Operations Management. Architect Manuel L. Torres Jr., Roof Manufacturing. Stephen Henry D. Pico Uy, Family Business Consulting. Patrick L. Yaren, Resto Bar Management. Rotary Club of Cebu Fuente. Vision. We see people of action, cultivating fellowship, integrity, excellence, leadership, diversity, service for everyone, every day. Mission statement: high impact leaders helping humanity.
Good evening, fellow Rotarians. Due to technical problems, our MC is incommunicado. So I'll proceed to introduce our guests and visiting Rotarians. We actually have, of course, we have Commissioner Julie Remondi, Rendoque, sorry. He will be properly introduced later. Then we have uh, President of the Rotary Club of Manila Bay, Joel Ferrer. We have past president of the Rotary Club of Manila Bay, Jackie Cruz, along with the past president also of Rotary Club of Manila Bay, Anna Yu. And we have another member from the Rotary Club of Manila Bay, William Emmanuel Yu. Welcome and good evening.
Good evening.
Good evening.
Good evening.
Like to introduce our guest speaker tonight. I'd like to call on past president and assistant governor Zone 1D, Zone 1B, sorry, Maricel Amores.
Okay, thank you so much, Past President Dave Karamihan. We'd like to say Great President Burns Amago, district officers if they are there, and of course our guests, fellow Rotarians, Rotaractors, guests, ladies and gentlemen, an amazing evening to you all. I have the singular privilege to introduce a self-made man who rose from the ranks, starting from a very humble beginning up to where he is now today. I doff my hat off on how he studied and commenced working as a casual laborer of the Department of Labor and Employment, then slowly working his way through as a stenographer, senior stenographer, stenographic reporter, secretary, board secretary, deputy executive clerk of court too. We all know the rigors of law school, and balancing it with his work is simply awesome, but successfully breezed through it and became a lawyer. Our guest speaker is a Juris Doctor and a Master of Public Management who graduated at the University of the Philippines, Cebu. Likewise, he took up Master of Laws in the University of Santo Tomas, University of Southern Philippines, and University of Cebu. He's a well-respected figurehead in the NLRC, that it came as no surprise that he subsequently held a presidential appointment as labor arbiter then executive labor arbiter, commissioner, and is currently holding the position of presiding commissioner after he was just appointed as such last December 14 to 2021. Paying it forward and giving back to the budding law students is part of his DNA, as he is a law professor teaching the subjects labor standards law, labor relations law, and labor law review in two schools of law in Cebu City, the University of Cebu School of Law and in Southwestern University. He is also a labor law reviewer. He shares his expertise with his fellow brother and sister lawyers as an MCLE lecturer on topics such as substantive law, labor relations law, and labor standards law, updates on labor relations law, ensuring sustainable communities, economy, and environment in the era of global challenges, employees' right to self organization. He gives back to the community through his speaking engagements in various labor and management fora with topics such as building a high performance team, management prerogatives, rights of employees, labor laws, legal implication, relationship of principal and independent contractors, alternative dispute resolution, and others. He has been recognized with notable awards: Loyalty Award for dedication to service with the NLRC for more than 40 years, Certificate of Commendation for achieving the Dolly Project speed by resolving labor cases within the required 6-month period, and Certificate of Commendation for meeting the NLRC case disposition target of achieving the zero backlog in pending cases from 2014 up to 2021. He is happily married to my lovely classmate and dear friend, Lisa Abelia, and has a beautiful daughter, Isa. Ladies and gentlemen, the presiding commissioner of the National Labor Relations Commission 7th Division, Cebu City, please welcome Honorable Julie C. Rindoque.
Thank you for that very generous introduction, Ma'am Amores, Maricel. Good evening, everyone. First of all, I would like to thank Ms. Maricel Borromeo Amores for inviting me as a guest speaker of this evening to talk about the law on termination under COVID-19 pandemic before the members of the Rotary Club Cebu Fuente. I also thank our very respectable, young, and dynamic president of the Rotary, Attorney Bernardino Amago IV, who made this momentous and significant activity a reality. And to all the officers and members of this very prestigious club who are joining this video conferencing, thank you. Indeed, I am honored as presiding commissioner of the NLC 7th Division to share with you some relevant laws and DOL guidelines, including amendment to the law involving suspension and closure of business affected by COVID-19 pandemic. I hope that despite the 1 hour limited time allotted to me to discuss this one book, actually post-employment can be discussed in one semester, and it is even contained in one book, book 6 and book 7, no, of the Labor Code of the Philippines. But in this evening, I will discuss them all in 1 hour only. No, I am honored that despite this limited period, our agency, our office could provide, I hope, no, to those concerned, positive contribution in the delivery of our services aligned with our mandate to effectively administer labor justice. Currently, while the devastating effect of this pandemic has slowed down in our jurisdiction, based on the latest findings by the interagency task force and by the Department of Health, as vaccine hesitancy among Filipinos is now down to just 10% as compared to last year when the vaccine hesitancy was about 30% of the Filipino. I think you have read the newspaper. It is still undeniable that for more than 2 years of pandemic, labor problems had cropped up as the suspension or closure of businesses and the suspension and termination of employment became prevalent. Erstwhile efforts to settle disputes between employers and workers were proven inutile as both parties suffered the same fate during the pandemic. But some of their differences ended up initiating labor complaints where intervention by third parties like conciliators, mediators, and labor tribunals is needed. Actually, my discussion is supposed to be confined on the following, no, which are all related to the law on termination of employment, such as the uh, uh, the provisions of the labor code that provides just causes for termination and the authorized causes, the substantive and procedural due process, the procedure of termination, where employment has to be terminated for authorized causes like retrenchment and closure of business, no? If we are to relate them in the present COVID-19 pandemic, and also the suspension of operation at exceeding 6 months, not considered termination of employment, but are grounds and the requisites, including the suspension of operation due to national emergency and other matters related to no vaccine, no work policy. Considering, however, that there are dole regulations or issuances, no, like the department orders or legal advisories issued by the Secretary of Labor and Employment in relation to COVID-19 pandemic, it is perhaps better and proper if we have to incorporate in our discussion relevant dole issuances for the guidance of everybody. So to begin with, what are the dole regulations or issuances or legal advisories now issued by the Secretary of Labor and Employment in relation to COVID-19 pandemic? Now, few of them are as follows. No, excuse me. We have this dole department order number 215 series of 2020. We have also the legal advisories number 31 series of 2020. We have legal advisory number 17, DAS B series of 2020. We have also labor advisory number 17 without DAS B or DAS A or whatever, series 2020. Labor advisory number 08, series 2021, and labor advisory number 03, series of 2020. And the recent labor advisory is the labor advisory number 1, series of 2022. Now, actually, the Department Order 215, series of 2020, which is the department order I first mentioned, and the labor advisories, no, which, as I said, I mentioned, no, in relation to COVID-19 pandemic, issued by the Secretary of Labor and Employment, they are not substantial amendments of the provisions on the law on termination of employment. I repeat, they are not providing substantial amendments on the provisions of the law on termination of employment under Book 6 of the Labor Code of the Philippines as amended, starting on the coverage under Article 284 up to Article 293 of the Labor Code. No substantial departure is made through amendments by the issuances of the Dole Department orders, except only few, no, which I will mention, no, related to COVID-19 pandemic, which this COVID-19 pandemic, it continues to batter innocent as follows: the issuances of the or by the Dole Secretary of Labor. Now, these are the provisions that are affected by the issuances of the Department of Labor and Employment issuances. No, the provisions of the Labor Code of the Philippines. They're as follows: Article 287 of the Labor Code, which contains provisions on probationary employment. The other article is Article 189 of the Labor Code that pertains to closure of establishment and reduction of personnel. And Article 292, yes, of the same code, which provides a situation as to when is an employment not deemed terminated. Now, these three provisions, no, Article 287, Article 289, and Article 292 under post-employment or Book 6 are the only significant provisions in the Labor Code that require a little bit of our discussion tonight for the effective guidance of those in the practice of law vis-a-vis their clients and those businesses which operations were suspended and closed, and those workers or employees where their employment has been suspended and terminated due to the nagging, adverse, and crucial effect of COVID-19 pandemic. And so, in relation to the probationary employment, no, the uh, in relation to this COVID-19. What is this Dole advisory issued by the Secretary of Labor? Labor Advisory number 17, series of 2020. Now, in this Labor Advisory number 17, series 2020, the probationary workers must wait 1 more month to be permanent. Now, we know for a fact that the term of employment of a probationary employee does not exceed 6 months, diba? If after 6 months, this probationary employee is required to perform his duty or allowed to continue working, then he is deemed to be regular employee. But under this Labor Advisory number 17, series of 2020, it is not automatic that after 6 months, this probationary employee will become a regular employee. He needs to wait for 1 month more before he can become a regular employee. Okay? So in relation to the above provision involving the provision which I said involving probationary employment, we have also provisional the Labor Advisory number 17. Now, this is a guideline clarifying the non-inclusion of the 1 month ECQ period on the 6-month probationary period. For purposes of determining the 6 months probationary period, the 1 month ECQ period is not included. Okay? So when there was a declaration of ECQ, no, and therefore, after the 6 months period, this period of 1 month where there is an ECQ has to be excluded before the probationary employee will be considered as a regular employee following the 1 month period of ECQ. Now, second, the Dole Department Order number 215. Now, considering that the same department order is citing a specific section 12, a specific provision in the implementing rules, no, which is section 12, rule 1, book 6 of the labor code, no. Let us first quote the cite to you the provision of the said implementing rules. I'm referring to section 12. Now, this section 12 pertains to suspension of relationship. Now, under this provision, section 12, no, rule 1, book 6 of the implementing rules and regulations of the labor code, it provides that the employer-employee relationship shall be deemed suspended in case of suspension of operation of the business or undertaking of the employer for a period not exceeding 6 months, the rights of the employees under the code, and in case of mandatory fulfillment by the employee of a military or civic duty. Now, the payment of wages of the employee, as well as the grant of other benefits and privileges while he is on a military or civic duty, shall be subject to special laws and decrees and to the applicable policy. So here's the question. What is the effect of the bona fide suspension of business operation not exceeding 6 months? Is this the same as temporary layoff or placing an employee in floating status? Now, the answer is a bona fide suspension of the operation of a business or undertaking for a period not exceeding 6 months is allowed, after which the employer shall reinstate the employee to his or to her former position without loss of seniority rights if he or she indicates his or her desire to resume his work not later than 1 month from the resumption of the operations of the employer. Okay? Now, if it has been held that an employer may validly put its employees on forced leave or floating status upon bona fide suspension of the operation of its business for a period not exceeding 6 months. Now, it is not employment of the employee, but only a temporary displacement. When the suspension of the business operation, however, exceeds 6 months, then the employment would be deemed terminated and the employer would be held liable. When the floating status of the employee lasts more than 6 months, they may be considered as constructively dismissed. But later on, you will know that there is an extension of another 6 months within which the law grants make the employers not liable for the said period exceeding 6 months, because under the Labor Code of the Philippines, the suspension of the employment or business operation not exceeding 6 months does not terminate or sever the employer-employee relationship. But under the Dole issuance, no, in relation to COVID-19 pandemic, there is a grant of another 6 months period. So the suspension of operation there, or the suspension of employer-employee relationship there, no, is extended to 1 year already, no, under the new issuance. Now, citing the Department Order 215, here are the salient features of Department Order 215. Now, Section 12, Rule 1 of the rules, no, implementing Book 6 of the Labor Code on suspension of employment relationship was amended, no, amend portion sa implementing rules by Department Order 215 series of 2020, such that in case of declaration of war, pandemic, and similar national emergencies, the suspension of the relationship between the employer and the employees may be extended for a period not exceeding 6 months. So clearly, with this Department Order 215, series of 2020, the period of 6 months business suspension as provided in the implementing rules is extended to another 6 months. In some, this period is in addition to the 6 month suspension already allowed prior to the amendment. And during this 1 year extended period, or a total of 12 months, the employer-employee relationship is suspended only, okay, when the suspension is due to the declaration of war or pandemic or similar national emergencies. So you can imagine, if there is merely a suspension of employer-employee relationship, if one of your workers will file a case for illegal dismissal within 1 year from the time he was suspended due to this pandemic, then obviously that complaint is dismissible for being filed prematurely, because there is no dismissal to speak of. Okay. What happens is that the employer-employee relationship is merely suspended. So if it is if the relationship is merely suspended, then there is no severance of employment. So there is no basis for illegal dismissal, because on the first place, there is no dismissal to speak of. Okay? Now, this is, however, subject to compliance with the following rules. Now, there has to be a report to the DOLE, the extension of suspension of employment 10 days prior to the effectivity thereof, subject to the inspection. And of course, during the period, the employees shall not lose employment if they find alternative employment during the extended suspension of employment. So you imagine your worker has found an alternative employment. Then the department order says that said employee is not deemed to have lost his employment, okay, during the extended period of suspension. Now, if retrenchment is necessary, during that period, if retrenchment is necessary during that period, before or after the expiration of the extension, the employee is entitled to separation pay. Okay, take note. The employer may adopt the retrenchment program, for example, if it found out that the business operation is suffering from financial losses. So in the exercise of management prerogative, it may retrench employees, but its obligation is to pay its employees separation pay and compliance with all the requisites, especially on the notice requirements to the DOLE and to the employees affected 30 days prior to the effectivity of the termination on the ground of retrenchment, in order that that retrenchment becomes legal. Otherwise, the employer will be held guilty of illegal dismissal. Now, also, the extension shall, even if the period is extended, still the employees remain to be entitled to separation pay, because the grant of separation pay is invested by law, that is conferred by law. So the law must be complied with. Okay? Now, in granting the separation pay, the first 6 months of suspension shall be included in the computation of the employee's separation pay. Okay? So take note also that in the department order, it says that the retrenched employees shall have priority in the rehiring. So far, okay ba? Did you follow?
Yes, attorney. Thank you.
Hello?
Yes, yes, Commissioner.
Okay, okay.
Yes, Commissioner.
Okay, okay. Now, okay, okay. Let me continue. Okay. Now, considering that the Department Order 215 mentions about retrenched employees who are granted priority in the rehiring, it is also proper that we have to know what is Article 289 of the Labor Code, which I mentioned. What is this Article 289 of the Labor Code all about? Now, this is a provision of law that concerns the closure of establishment and reduction of personnel. Now, under that Article 289, the employer may terminate the employment of any employee due to the installation of labor-saving device, redundancy, retrenchment, to prevent losses or closing or cessation of operation of the establishment or undertaking, unless the closing is for the purpose of circumventing the provision of this title under this article by serving, these are the requisites, by serving a written notice on the workers and the Department of Labor and Employment at least 1 month before the intended date of the separation or termination on the ground of separation. There is a requirement that the employer has to pay separation pay. Now, in case of retrenchment, to prevent losses, and in case of closure or cessation of operation of establishment or undertaking, not due to serious business reverses, take note, not due to serious business reverses or losses or financial reverses, the separation pay shall be equivalent to 1 month or at least 1/2 month for every year of service, whichever is higher. A fraction of at least 6 months shall be considered 1 whole year. So you can imagine that during the period of pandemic, if the business operation is suffering from financial losses or financial reverses, this provision is applicable. No, this provision, no, Article 289 has to be applied, and the requirements thereof on notice and the grant of separation pay, no, they have to be strictly complied with, because violation of this provision will tantamount to the finding that the employer is guilty of illegal dismissal. Okay? So, Mona, that is something that you have to imagine, when you retrench employees. But, of course, probably some of you have no idea of what retrenchment means. No, meaning retrenchment, it is a termination of employment initiated by the employer through no fault of the employees and without prejudice to the employees, resorted by management during the following, like for example, period of business recession, pag gani business recession kana, pwede returns, industrial depression or seasonal fluctuation, kanya during the lulls occasioned by lack of work, no, kung walay trabaho or orders, shortage of materials, then considerable reduction in the volume of the employer's business, kana manginana, and introduction of new methods or more efficient machinery or automation, kana in those cases, pwede na mag-retrench, no? Or napay mga other grounds, no? O kaning actual losses to minimize, prevent, or prevent losses. Kanang manginana, then the organization, pwede po, it could be a reason to retrench employees. And probably there is a streamlining, no, in the company, no? O kanang mga inana. So these are things that you have to consider. But of course, it is a must that you have to know the requirements, no, for the validity of retrenchment. Okay, how do you determine the validity of the retrenchment? I already mentioned that, no, the notice requirement and the separation pay, including good faith. You have to be in good faith, no? Okay, there is a provision there that if retrenchment is resorted to in order to circumvent the rights of the parties, then you may be guilty of illegal dismissal. But what is the test or standard to determine the validity nga the company is actually losing in order to justify retrenchment? Okay. Kung ano yung no? These are the requirements, no? If you prove that the company, if you can prove that the company is suffering from losses, then you have to justify the following: that the losses expected should be substantial, no, and not merely minimal in extent. Kanya ang substantial loss, no, must be reasonably imminent na, no, and kaning ang retrenchment is reasonably necessary and likely to effectively prevent the expected losses. And it has to be proven by sufficient and convincing evidence. And how do you prove kaning losses to justify retrenchment? Well, you just have to submit financial statements audited, no, audited by independent external auditors, no, mo na siya. And the audited financial documents shall consist of kanang mga annual balance sheet, profit and loss statement, and kaning mga income tax return. So more or less, these are the requirements of the law before you can say that, pandemic, before you can say that the retrenchment is valid during the time of pandemic. Pandemic, the existence of pandemic is not an excuse. No, it is not an excuse for you not to comply the requirements, no, for the validity of the retrenchment. The requirements for the validity of retrenchment must still be complied with, no, even during the time of pandemic. Okay. Now we are talking about retrenchment, no. What about the closure of business? What's the main requirements of closure of business? Well, of course, there must be a decision to close, no, or cease operation, no, of the enterprises by the management, and that the decision must be in good faith also. And also, there is no other option available to the employer except to close or cease the operation. So this requirement must be complied with by the employer in order that the closure of business is considered valid. Okay? Now, more important provisions, no? I know that this 1 hour period is not enough, no? Probably there may be another forum where we can further discuss, no, laws on termination, because as I said, the provisions on the law on termination is so comprehensive, and even it's contained in Book 6 of the Labor Code of the Philippines, no, and it's taken up 1 semester in the law school. Okay, now we have another labor advisory, issued by the Secretary of Labor, Labor Advisory number 17-B. What is this? Labor Advisory number 17-B, series of 2020. Now, this labor advisory sets guidelines on employment preservation upon resumption of business operation. Now, the establishments are, when feasible, highly encouraged to adopt work from home or implement telecommuting arrangement under this labor advisory number 17-B, series of 2020. Muna, this issuance, no, sets guidelines on employment preservation upon resumption of business operation. Okay, now the establishments are encouraged, highly encouraged, to adopt work from home or implement telecommuting arrangement. What is this? Work from home. arrangement. Is this the same as telecommuting? What do you think? Now, this telecommuting refers to a work from an alternative workplace, dili sa uh, workplace good sa company, dili, no? It refers to a work from an alternative workplace with the use of what? Telecommunications and or computer technology. Mana siya? So, when you use telecommunications or computer technology in a place other than the workplace, the regular workplace, the principal work of business, no? Place of business, I mean, okay? That is telecommuting. Okay. Now, considering that the work from home involves residence or home, no, we are trying to distinguish work from home from telecommuting. Now, considering that kaning niyang work from home involves residence or home as an alternative workplace, work from home is essentially telecommuting when there is use of telecommunications and or computer technology. Otherwise, work from home lagi na siya. Okay? But if you are using uh, a technological device, no, that is already telecommuting. Okay? So, work from home is essentially telecommuting when there is use of telecommunications and or computer technology. I think this was asked in the recent bar examination. Distinction between telecommuting and work from home. Murag nakuha na siya na nagawas na siya. Now, if there is work from home, there is also a flexible working arrangement. Now, these are the ways, no, or measures where the employer may adopt during the period of COVID-19 pandemic. These are measures that may be adopted by the employer in order to avoid, no, to avoid, infection of COVID-19 disease. Now, another one is the flexible working arrangement. What is this flexible working arrangement? It also refers to alternative work arrangement or schedule other than the traditional standard work hours, okay? Work days or work week. The DOLE recognizes the desirability and practicability of this arrangement that may be considered by employers after, of course, consultation with the employees. But its effectivity and its implementation shall be temporary in nature only, subject to the prevailing conditions of the company. Okay, so what are some of the allowed or recognized FWA or flexible work arrangement? So may mga recognized flexible work arrangement na gialaw sa balaod. So these are the following: telecommunicating, mo man yung mga these are things that the employer may adopt, no, during emergencies or pandemic. Okay. Now, these are the following: telecommuting, work from home, no, then reduction of work days, rotation of workers, the forced leave, and kani pong compressed work week. Oh. And kaning there is also a broken time schedule, no, and the flexi holidays schedule where the employees agree to avail the holidays at some other days provided that there is no diminution or existing of the existing benefit. Okay, note also that in relation to this labor advisory we mentioned, labor advisory number 17, the same labor advisory provides that as an alternative to termination of employment, instead of terminating an employee or closure of business, any or combination of the following may be adopted. So, kung may mga alternative move by the employer that instead of terminating an employee or closing its business, you may adopt the following method or arrangement. What are these? Transfer of employees to another branch or outlet, no, of the same employer. What else? Assignment of employees to other function or position in the same or other branch or outlet of the same employer. Transfer, ha? Of course, this is not constructive dismissal kay pandemic man, di ba? Oh, there's you are left with no choice, no? If only to save the business operation and help save also, provide the needs of the employees. Okay, pwede assignment of employees to other functions, no? In the same office or in another branch. Reduction of normal work days, no? Per day or week, reduction of normal work days or job rotation, no? Alternately providing workers with work within the work week or within the month. Oh, yeah. Job rotation or partial closure of establishments where some units or departments of the establishments are continued while other units or departments are closed, and other feasible work arrangements, considering the specific peculiarities of different business requirements. Okay, so these are the measures. But take note that this alternative work scheme or flexible work arrangement are temporary in nature and shall be adopted only for as long as the public health crisis exists. Okay, so take note muna. So having said all those laws and those regulations and issuances, let me pose this question. Okay, during the COVID-19 pandemic, what are these options that do not result in termination of employment during the COVID-19 pandemic? What are these options that do not result in termination of employment? Well, I just enumerated earlier, no? And these are the following. Now, some of these notable options are as follows. Katong work from home, di ba? Kaning flexible work arrangement, di ba? They're still employees. No. So that is not considered as termination of employment, di ba? Katong adoption of compressed work week, the bona fide suspension of business operation at exceeding 6 months. So if there's a question on the options that do not result in termination, what are the options that result in termination during the time of pandemic? Of course, these options refer to the authorized causes for termination of employment under the authorized causes provided for under the Labor Code of the Philippines. The one which I or discussed, no? Okay, namely installation of labor-saving device, redundancy, retrenchment to prevent losses, closure or cessation of business. So these are the options that results in the termination of employment. Because in the first place, these are authorized causes for termination of employment. Okay, the one exercising this right is the employer because it is part of the employer's management prerogative that is conferred to them by law. Okay, now in terms of what and how much the employer should pay to the employee. Okay, what are the main distinctions between the first one, ito mga flexible work arrangement, and the second class of employer? So may distinction ato. Well, in the first class of options, which we mentioned, okay, not involving termination of employment, the employee continues to receive wages, and the option or options are subject to the principle prohibiting diminution of benefits and prohibition against discrimination. While in the class of option, mga authorized causes, the employer, of course, is when the company is suffering from serious that may be given to the is on the ground of closure of business due to okay. So these are things that you have to now in another labor advisory that we mentioned, no, labor advisory number 3, series of 2021. Okay, this is the this provides guidelines, no, on the administration. Now, under this labor advisory, no cost of vaccination in the workplace shall be charged against or passed on directly or indirectly to the employees. Okay, the covered establishments and the employers shall endeavor to encourage their employees to get vaccinated. Now, under this labor advisory number 3, series of 2021, vaccinated. However, any employee who refuses or fails to be vaccinated shall not be discriminated against in terms of tenure, promotion, training, mga pay, and other benefits among others, or terminated from employment. Okay? Take note that the no vaccine, no work policy is not allowed. So this answers the question of whether or not a no vaccine, no work policy has legal basis. And the answer is in the negative. There is no legal basis. The legal basis why the no vaccine, no policy is not allowed is Labor Advisory number 03, series of 2021. Okay? Now, in Labor Advisory number 08, series of 2021, earlier we mentioned Labor Advisory number 03. And now we are talking about Labor Advisory number 08. Now, this pertains to promotion of COVID-19 vaccination in the private sector. Under this labor advisory, all employees in the private sector, except those who are ineligible or disqualified for health reasons, are highly encouraged no, to get inoculated with COVID-19 vaccine. Kinahanglan, i-encourage sila, highly encouraged to be vaccinated. Mao na siya. Oh, wala dili it is not mandatory, no? Only encouragement, highly encouraged again. But there are few questions that may be asked, no? If you cannot ask me questions relevant to this vaccination, and or probably if you have reserved questions, no, that may be raised, no, after my lecture, because there is an open forum, I would anticipate some of the questions that may come up, no, and these questions may relate to the following. I will just because I have formulated a few questions, no, anticipating a lot of questions regarding vaccination, and I also made the answers, corresponding answers to those questions I made. Now, the first question is, can an employer require compulsory vaccination? If yes, are there any exceptions or specific circumstances that an employer must consider? Now, the answer to the first question, if there is a compulsory vaccination, the answer is no. An employer may not require compulsory COVID-19 vaccination for its employees. Okay? Now, the Philippine government, based on the labor advisory we mentioned, has launched an information drive even, no, on COVID-19 vaccination, highly encouraging only the public to have themselves vaccinated, but making it clear that vaccination is not mandatory. Another question, can employees refuse to be vaccinated? Oh, can employees refuse to be vaccinated? Kaya na may dagahig ulo, mga employees, di ba? Oh, kita mao na natong pa-vaccinate kay hadlok tas COVID. Ang kaning uban di pa-vaccine. Oo, kay ulo kay I don't know sa na ilang reason, no. may other mga reasons nga not acceptable. Anyway, we have to answer this question. Can employees refuse to be vaccinated? How does an employer need to balance its obligation to provide a safe work environment with an employee's right? Oh, may conflict. Oh, saan ba na? So the answer to the first question, can employees refuse to be vaccinated? They can. Yes, the answer is yes. Employees may refuse to be vaccinated, but the employers may exert efforts to educate their employees about the benefits of COVID-19 vaccination and consider subsidizing the cost of the vaccine to incentivize vaccination. But it may not require compulsory vaccination. Okay? Employers, however, are still required to provide a safe work environment by implementing strict COVID-19 prevention measures in the workplace, including the practical social distancing within the workplace, the temperature checks, and no, the compulsory use of face masks, the frequent sanitation, and adopting flexible work arrangements to reduce the risk of COVID-19 exposure. See? Oh, mana siya? Now, in the event of a refusal, can an employee be dismissed for refusal to comply with the employer's vaccination policy? Can the employer dismiss the employee on the ground of insubordination? Okay, Anna, or violation of the vaccination policy of the employer? Will the employee's refusal constitute a just cause for termination? Now, the answer there is no. An employee may not be dismissed, no, just for refusing to comply with the employer's vaccination policy. The Philippine Department of Labor and Employment recently issued, okay, a labor advisory which we already discussed earlier, that any employee who refuses or fails to be vaccinated shall not be discriminated against. He shall not be discriminated against in terms of tenure, promotion, training, pay, and other benefits, or terminated from their employment. As I said earlier, no vaccine, no work policy shall not be allowed. Okay? So I think my time is up. No? That would be all. Thank you very much.
Wow. Thank you very much. I'm we're really very proud and honored to have you here, presiding commissioner.
You're welcome.
Okay.
Yes. Thank
So
you.
you're open for the question and answer, right? So we have some questions here from our
Okay.
audience. And the first question I've seen is that if since we cannot force the employees, by the way, before we go to that, let's give Honorables Julie Rendoque a round of applause. It was very thorough, like I was sitting back in
Thank
law
you.
school. Okay, so
Thank
yes.
you. Thank you. Mm.
So the question is, since we cannot force the employees to be vaccinated, this is from our past president, Emmy Tesalona, can we ask the employees to submit to weekly RT-PCR exams? And whose
Okay.
expense would that
No, there's no problem about that. No. The only I think if I'm not wrong, part of the issuance of the interagency task force, no, where can examination, PRC test, no, may be done, no. I think 1 week, every 1 week or 2 weeks, no,
okay?
to ensure the safety of the employees. It's for their benefit. That's why part of the labor advisory, no, tells us about the obligation of the employer on the advantage, no, of being vaccinated. So aligned to that, there is also a corresponding obligation on the part of the employees to have tested whether or not they are infected with COVID-19 pandemic for the safety of all in the workplace.
Yes, thank you so much for that response. Here's another
Welcome.
question. Can my employer require me to use paid sick leave if I am quarantined for COVID-19?
Yes, that is one of the measures that may be adopted by the employer. The employer may require the employees to avail of his sick leave credits, no, during the period of quarantine or during the period of isolation.
Yeah, thank you so much. So we have
Welcome.
hands that's being raised here. We have from past president Dave Karamihan. Did you raise the question? Are you the one raising the hand, or is it President Burns?
Me, ma'am. Me, ma'am.
Okay, go ahead.
Yeah, I have a question regarding to closure of business. But you have to establish a certain number of years prior of business losses. Now, what happens? This pandemic is unprecedented, and you incurred losses. Do you still need to prove that you were at a loss for the past 3 years when this pandemic is unprecedented? Losses are so. Don't you think it's justified that the losses for just for this pandemic alone would allow us to go for closure or whatever?
Yes, so there is no need to establish that the employer has been suffering financial losses for the past 3 years, especially in this case when the pandemic started 2 years ago. Diba? The only legal requirement to make the closure valid are those requirements which I mentioned. Now, what are these? You have to prove that indeed the business is suffering from financial losses, or if you can prove that the business is suffering from serious business reverses, I would say that it's much better. But I would say that the employer is not obliged to pay their employees affected with separation pay if you can prove that the business is suffering from serious business losses. But if the business losses are not serious, okay, they are not serious, but still they are losing, then the requirement of the law must be complied with. And those requirements are as follows: the notice, 30-day notice to the affected employees and to the Department of Labor and Employment 30 days in advance, and the grant of separation pay equivalent to one half salary for every year of service. These are the only things that are required in order that the closure of business becomes valid. Okay, and you will not be charged of illegal dismissal because violation of these legal requirements makes the employer liable for illegally dismissing the affected employees.
Okay, thank you very much for that, Commissioner
Welcome.
Mendoca. There is another raison from our guest, all the way from Rotary Club Manila Bay. We'd like to call on Dr. William Emmanuel Yu. Go ahead.
Bida, nalagoy question. So, kung if the employer is in an industry where the customer is requiring that the engineers deployed have to be fully vaccinated. So, ang amo mga customers will require that our engineers are fully vaccinated. Nya na ami, for example, na engineer na dili magpa-vaccine. So, how do we handle that situation? Of course, now we're trying to convince that engineer to get vaccinated. Pero lisod man na may religious grounds daw. So, unsaon man.
Well, the employer has no choice but to follow the law by encouraging, urging, more again this is the limitation imposed by law, no? Because under the law, the employer cannot discriminate the employees who refuse to be vaccinated. Kay wala may law. There is no law actually that if an employee refuses to be vaccinated, he can be terminated from the service. And it is not one of the just causes for termination of employment, the refusal to be vaccinated. Okay, even if there is a vaccination policy that the employer has adopted, that policy apparently has no legal basis, di ba? The only legal basis is that the policy should not discriminate the employees, but must highly encourage only the employees to be vaccinated. So you have to keep on telling, probably you have to conduct a series of meetings to enlighten the advantage and the disadvantages of employees who refuse to be vaccinated.
Yeah,
So
ang
that at
among
the end,
among worst case,
para,
yung worst case
oh,
scenario, can we just do ano na lang, we will just do a redundancy or retrenchment, then just pay the employee separation. Kay dili man useful, for example, kay the business requires that engineer
yeah,
to the customer, di ba niya? Wala
mm,
walay recourse, di ba?
yeah, I understand. But kinahanglan na yun nga, you have to comply the requirements for the validity of resorting to redundancy or retrenchment. Na yun, kinahanglan you have to
Pwede
prove
man, we'll get
losses,
another engineer who is
yeah.
vaccinated and the
Oh,
customer will allow, di ba?
mo na yung problema kay kung mukuha mo og lain, why
Ay,
problema no kung mukuha mo og
first
lain,
choice siya
but
dapat.
without terminating the engineer who refused to be vaccinated, kung mukuha mo og lain, no problem. Pero kung imong alisdan agatong engineer who refused to be vaccinated og lain, mo na yung problema because that is illegal dismissal na. But if I were you this is just an opinion. There are many reasons to impose discipline on the employees.
Yeah, but
Do
the
not focus on failure
ano
to
naman ko,
vaccinate. Oo.
pwede din naman 'di ba, like we follow the requirement of DILG that says na if for example the customer may allow in some cases, but the testing is charged to the employee na. So we are in no obligation to pay for the testing, parang like that. If for example there just so happens to be clients na
Pero
musugot na musulod sa iyang premise pero magpa-test siya, and we will tell the employee that you pay for your own test. Pwede din na, di ba?
Yeah. Pwede na siya.
To
Pero
make it financially expensive, so cheap
if
for a vaccination for them.
And besides, if these employees do not really want to be vaccinated in the workplace, they can be separated, man. No, employees who refuse to be vaccinated or unvaccinated employees, and those employees who are vaccinated, pwede man na sila i-segregate. That is allowed.
Mangita na lang
Diba?
may mangita na lang may mga
Lugar,
mga broom closet niya isulod na mo, di ba?
Ana, para at least safe ba? Wala problema. Kaya you can imagine if you're charged of illegal dismissal, the consequent effect of the finding of illegal dismissal is for you to reinstate the employee and pay the employee illegally dismissed with back wages from the time he was illegally dismissed up to the time of act of reinstatement. And for many years pending ang kaso, you will be required to pay his salary during those time and while he was not working. Mali problema. So better
Thank
na
you,
lang
Tom.
ang itataog way.
Convinced na lang.
Welcome. Bisaya lagi ka.
Salamat,
Bisaya
Tom.
lagi ka.
Bisaya ko.
Okay, welcome, Doctor.
Thank you very much.
You're welcome, Doctor.
And then, but before that, Honorable Julie Durindoken, we'd like to acknowledge the presence of our District Governor of 3860, Ana Bumagat. Gov Ana, want to say hello?
Hello, good evening. This is a very interesting talk that you have this evening. So I'm learning a lot and I'm taking down notes. So thank you so much, her, for that very enlightening sharing, and to the club for having this topic at a very timely time. No. Good evening to everybody. Thank you.
Thank you so much, Gov Ana. Thank you very much for gracing this affair also. Here's a question from our sister club also. Attorney Jose Ferrer of the Rotary Club of Manila Bay. It says here, can an employee who happens to be a team leader of the company's emergency services unit be dismissed from service when he attends a meeting with his officials after he is informed that his antigen test result is positive, claiming that he doubts the authenticity of the test? He is then retested using the antigen test again, and the result is positive again. And he is informed of the result but proceeds to his workstation and works for an hour, exposing himself to other employees. So can an employee who happens to be a team leader at that, no, for the risk emergency services unit be dismissed from service when he was tested positive in the two antigen test? Did I get that correctly, Attorney Seferer?
Yes. Oo.
Thank you.
Okay.
Correct. Thank you,
Okay.
thank you.
Yeah, okay. Okay. Now, so far, the findings that an employee is found to be positive of COVID-19 is not one of the just causes for termination of employment. Diba? If you notice, okay. Ang ato tanawan ana no, we have to sympathize, no, the condition of the victim of COVID-19. So it is as if we are trying to exacerbate the situation, trying to make that having suffered COVID-19, he will eventually lose his employment. Okay, so the obligation there is to have this COVID-19 victim isolated, di ba? Or require the employee to go to the hospital and have his infectious disease cured. No, I think the employer, if the employer is generous enough, has to help the victim recover instead of dismissing him from the service. Logi kayo, inano. Ang ato lang basis nga it's not one of the reasons, no, or just causes for termination of employment. The only provision of the law regarding the disease, no, as basis for termination of employment are the following. When the disease is first, of course, there has to be a finding, a certificate, no, medical certificate coming from the public health physician, certifying therein that the disease suffered by the worker is incurable, no, for 6 months, inginana, and the certificate must be issued by the public health physician. Now, this is an alternative way of terminating an employee if the employer really would insist, no, on terminating the employee. Now, on the ground of disease and with all the requirements under the law, such as the medical certificate issued by the public, not private, public health physician, you know, and the certification that it is incurable and it is hazardous, it is infectious, no, the obligation of the employer is to grant the employee a separation pay equivalent to 1/2 month salary for every year of service. Okay.
Okay. Thank you very much for that response. And we have here a question from one of our spouses, Honorable Julie. It is Dr. Christina Sinerpida. The floor is yours. Great.
Hi, good evening, sir.
Good evening.
Correct me if I'm wrong, but there's an executive order requiring the employees, not, of course, not to be, we can't force them to be vaccinated, but to present a negative RT-PCR every 2 weeks at their expense. So supposing, and then if they really refuse to be vaccinated, no matter how much we encourage them or educate them, and then they're supposed to uh, they cannot go, they can stay at home, and then until their vacation leave and their sick leave are um, they accumulate the accumulated
Exhausted.
vacation
Yeah.
leave and sick leave, yeah, uh, is already gone, no? So after that, if they still refuse to be vaccinated and they still refuse to have submit an RT-PCR test, what happens then?
Yeah. If you are soliciting my opinion, no, and if I am the counsel for the employer, the retained counsel, no, for the employer, I would advise my employer to adopt this alternative work arrangement. No, you mentioned earlier that there is what we call a work from home arrangement or flexible work arrangement.
Sir, supposing this
More or less, yeah.
it's a health
You
facility like in a hospital,
yes.
so they really have their physical
Okay.
presence needs to be there. So what happens then
Mm.
if they really refuse?
Then then I think you have to assign the employee to another another work, no, related to related to his function, or
Okay.
a function that or a job that is required in the hospital, diba? And ensuring at the same time for the safety of other personnel that at least you would you you are preventing the infection of his diseases with the other co-employees, something like that. So assignment to other function is advisable, no? If he would really insist, no, to merge himself or converse himself with his co-employees. He cannot do that because the management has also what we call management right recognized by law. Okay.
Thank you very much, sir.
You're
Okay.
welcome.
Thank you very much for that. There is a special message for you, Honorable Rendoque. It says here from our no less than our President, Bernard Burns Amago. He says that truly, I could not thank enough our guest speaker, Commissioner Julie Rendoque, for taking time to be with us tonight. He heads the most hard-working tribunal, NLRC 7, which always reports a zero backlog of cases. That only speaks volumes of how dedicated Commissioner Rendoque is to public service. So that is a beautiful message from our president. And we are really indeed very honored to have you here. Are there
Thank
any
you.
further
Thank
questions?
you very much.
Yes, it's I know how busy you are, how many cases there are, and then it's and yet you you accommodated us tonight. Are there any questions?
No problem.
No other question. Oh, there's another. Let me see. Okay. There's no other question. So, with that, we'd like to ask our president, Burns, and we would like he would be giving you a token of his appreciation to gracing us tonight in our, this is a very insightful and beautiful conversation discussion that not coming from no less than the presiding commissioner of our National Labor Relations Commission in Cebu City, Region in 7th Division. So thank you very much. President Burns?
Again, thank you, Commissioner Julie, for being with us tonight. And it is with great honor and pride that I present the certificate of appreciation to you for your invaluable time and expertise as guest speaker at the 20th Rotary Club of Cebu Fuente General Membership Meeting given this 21st day of February 2022 via Zoom. Signed by yours truly and our Secretary, Jose Marie Ponce. Thank you so much, Attorney Julie, Commissioner Julie, for being with us. Thank
Thank you
you.
also. Yes. Thank you. Thank you to all of you for having me. Thank you.
Thank you very much again. So
Okay.
So,
Okay.
so at this
Okay.
point, we're
Next.
supposed to have
Can I leave
yes, sir.
now?
Sure, sir. Thank you so much again. So at this point, we're supposed to be discussing the business matters, but in deference to our guests tonight, we will do that internally. Just allow me to thank our governor, Ana Luisa Bumagat, for being with us tonight, as well as the Rotary Club, our sister club, the Rotary Club of Manila Bay, headed by LCP President, Attorney Joel Ferrer. A lot of their members also are present here tonight. I can see past President Jackie Cruz a while ago. I also saw past President Ana Yu. So thank you so much for being with us. Now, I'd just like to take this opportunity to invite everyone to attend our next meetings talk about can there be unity without accountability or peace without justice. This is to be delivered by Attorney Ruben Carranza, a staunch advocate for transitional justice. Another interesting topic. So may I request everyone to please open your video so we can have a picture taking. So Pep, please take care of taking the picture.
Okay, ready? 1, 2, 3, smile. Another one. 1, 2, 3, smile. Okay, thank you.
I also saw past Assistant Governor Ricky Andres. Thank you also. Our good friend of the Rotary Club of Cebu Fente, Ricky Andres. Thank you so much. So there being no other matters to be discussed, I hereby call this 20th General Membership Meeting adjourned. Fellowship continues.
Okay.
Thank you so much. Govana, thank you for being with us. Govana, we're already discussing possibility of past President Joe Yap is also here. Thank you, past President Joe.
Happy Paseo de Rojas.
Hi, Paseo de Rojas representatives. Thank you.
President Joya.
Govana, we're already discussing possibilities of blended, if not face-to-face meeting. I'm hoping we can do that in March, at least once a month. Maybe we can do that fellowship evening. I will defer to your schedule though. I will look at your calendar, Govana.
Okay, I'll let you know because I am available on March 11 to March 19. March 8 to March 19. So I'll let you know, Attorney Burns.
Sure,
Nice to know. That's very
so
good.
Anna, you may want to invite the club this Monday also.
Yes, but we don't have the poster yet. They haven't sent it to me. But I and our executive director of the District Disaster Management Incorporated, Archie Gamboa, will be featured in the Baletaktakan. So we will just post the poster once they send it to us. I will be, co-hosting Archie with the main speaker. So hope you can join us then. Thank you so much for a very informative talk. Thank you so much for the invitation.
Thank you, Gob.
Thank you.
Nice to see everyone again. No? Past President Joe, thank you. Thank you, Govana, once again.
Okay, bye-bye. Thank you.
Oh, Steve, it's showing us all.
Wala na si classmate Joel.
Yes. Natipaw ba ko?
Thank you, Attorney Joel.
Bye-bye.
Thank you, mate.
Bye-bye.
Bye, Attorney Joel.
Thank you, Joel.
Bye, PDG. Gutom na.